Hi, I'm Kent Berk at the Scottsdale, Arizona law firm of Berk and Moskowitz, where we handle probate, estate, trust, and other disputes in Arizona. I'm going to discuss today what happened in the case of the estate of Fred Kirkus, decided by the Division II of the Arizona Court of Appeals on March 8, 2012. This case involved overlapping probate and community property issues under Arizona law. As many of you know, Arizona is a community property state, which means that any property received by either spouse during marriage, other than by gift or through someone's will, is generally presumed to be community property and is owned 50% to each spouse. In this case, Fred and Gloria Kirkus were married. Fred had had a prior son, Joshua, by a prior marriage, and Fred established an IRA, an individual retirement account, while he was married to Gloria. Initially, Fred designated Gloria as a 100% beneficiary of the IRA account, but later changed the designation to be 17% to Gloria and 83% to his son from the prior marriage, Joshua. Fred then died, and Josh wanted to get 83% of the IRA account, but Gloria objected and said that Fred's change of the beneficiary designation form to Josh, leaving him more than 50%, or leaving actually less than 50% to Gloria, was a violation of Gloria's community property rights in that IRA account. So she argued that the change of the beneficiary to Josh should be invalidated and that she should have been given at least 50% of the IRA account. The trial court initially agreed with Gloria and used an itemization approach where each community asset is individually and separately analyzed and set aside the beneficiary designation, giving 83% of the IRA account to Joshua. The Arizona Court of Appeals reversed and basically took the approach that all community assets need to be evaluated and valued to determine whether the surviving spouse, Gloria, in this case, received her 50% of all community property assets, and the Court of Appeals remanded the case back down to the trial court to determine whether Gloria would still receive 50% of all community assets, even if she was only going to receive 17% of this one particular community asset, the IRA account. And in fact, in that case, it was undisputed, uncontested, that the IRA account was community property. The court did point out that changing a beneficiary on an IRA account is a permissible non-probate transfer, meaning it doesn't need to go through probate, just like a co-account holders on a bank account or a payable on death designation of a bank account. But the court did point out that in light of the community property laws and Gloria's interest in the community estate, that the non-probate transfer by Fred was subject to his duties to preserve Gloria's 50% interest in all community property. So Fred could not perform a non-probate transfer, changing the IRA designation, and essentially steal part of Gloria's interest in the community estate. So the case was remanded to determine whether Gloria would still receive her 50% interest in the estate. You can monitor our website, azestatelawyers.com, or give us a call if you have any questions. Thank you.